Okay, so this meeting is now being recorded, as we all heard. So welcome everyone. This is the HR and Employment Roundtable, which we hold bi-monthly for the benefit of chamber members, mainly employers. And we've got a few lawyers and employment lawyers. We've got Chris, we've got Simeon. I'm just going to open this forum today by saying we are coming across quite a few, in my line of work at least, quite a few disputes, shall we say, for want of a better word, or differences between employers and employees. And a number of times we notice that employers have, in the absence of professional advice, be it advice from HR professionals or employment lawyers, they have initiated a without prejudice conversation when actually there was no need for one to be had, simply because there was no actual dispute. And that's kind of complicated matters. And I think the whole objective of today's roundtable is to talk about contentious issues and also, highlight what is the real difference between a protected conversation and a without prejudice conversation. What is the main focus being Section 111A, of the Employment Rights Act. So it's just over to the lawyers in the room, and just want to understand whether you firstly come across situations with your clients on how, where there's just been a wrong start to a contentious issue, and just if you can just share best practice on how you kind of go about unraveling that and easing it for both parties so that the matter is resolved, if possible amicably, but eventually, yeah, if it has to end up in tribunal, it does. But what is really your experience?
Yeah, I think from my end, certainly, I've come across cases where employers perhaps haven't quite understood the difference between a protected conversation and a without prejudice conversation. You say that often they'll try and initiate a without prejudice conversation when there isn't actually yet a dispute taking place, which of course is one of the main differences between those two types of conversation. And also, I've had employers certainly when I've had clients feedback to me what's happened in allegedly a protected conversation, vice versa, where employers have been talking about things that would fall outside of the scope of what is protected by a protected conversation. So those would only apply to unfair dismissal claims, whereas I've had employers try to bring up things that would relate to other areas, which then my clients would be able to talk about in proceedings moving forwards, and aren't technically protected by those conversations. So that's a common pitfall for employers. I think if there was more awareness as to what actually is protected by a protected conversation,
Exactly.
As opposed to what would just fall within a general without prejudice conversation, then so many issues for employers down the line could be avoided. So it definitely is an area where, it's sort of in a recent case, actually, it's something that's often misunderstood by employers, in my experience at least.
Yes. Yeah. It's interesting that you see a similar kind of pattern. Chris, what has been your experience with your clients?
Yeah, no, I think Simon's absolutely right. I think if you go off on the wrong footing, the danger is that you're potentially destroying the privilege that attaches to the entire conversation, and so perhaps it's that misunderstanding about the privilege and how it attaches, which can cause the issues, because generally without prejudice conversations can take place at any time. So pre-termination, post-termination, middle of claims, right up to the trial, and so forth. Whereas protected conversations under the statutory formula, which is a form of privilege, the other is common law, only works pre-termination.
Yeah.
So essentially, as already been said, if without prejudice, you need a dispute, and as long as there's a dispute, there's a genuine offer of settlement, you can make a proposal. It doesn't have to be acceptable, it doesn't have to be even realistic. It just has to be genuine in that sense, and it will have that protection. And then the parties, the other side, won't be able to open that up, and it's not admissible in legal proceedings. That's why it's so critically important, because if the wrong formula is used in the wrong circumstances,
Absolutely.
that's when you get the potential exposure. I mean, if in doubt, I mean, I think there's nothing wrong with the usual shotgun, which is, you know, without prejudice, subject to contract, protected conversation pursuant to Section 111A of the Employment Rights Act. You know, and hopefully both will apply, but if not, one will apply.
Yeah.
And at least you're sort of lining up the argument that you've got. But I mean, I haven't had this. I've had discussions and arguments about it, but it's always been in a contained sense. It's never got into litigation. But there is that famous case. Is it BNP Paribas, where I think the employer in answering the employee's grievance, and I believe some facts are sort of lost in the mist of time, so forgive me, I'm not quite got it at my fingertips, but I think from recollection, it was about a maternity leave scenario and return to work or flexible working associated with that. And in the middle of the conversation and the grievance raised by the employee, the employer suddenly said, look, okay, this isn't really working. Why don't we go a different route? Here's a without prejudice offer. Now, it didn't work because there wasn't a dispute. There wasn't an obvious dispute, but it wasn't capable of being covered by the statutory route because, of course, it wasn't unfair dismissal. We were talking about a discrimination aspect, and no doubt when that went to the tribunal, having had the preliminary finding that it was an open conversation, it was rather sort of determinative of the outcome. I suspect what followed afterwards was a settlement discussion rather than anything else. So,
Interesting.
Simon, I don't know if you've had that sort of experience.
I
Yeah,
haven't had
and
direct
just
experience with that, but certainly come across. I know a colleague of mine, I've heard a pretty similar case. I need to get the details from him, but yeah, I'm sure that kind of thing does happen often.
I will read up on that case, Chris, and actually maybe I'll just also post it along. I'll just send it to Beth along with the, you know, when we put out the recording. But just out of interest, do you remember at all whether that grievance was ultimately responded to at least, or did it just branch off into a without prejudice conversation and just took off from there? Did they even complete the grievance process in that
No,
situation?
I think it was interrupted because I think
It was interrupted. Okay.
Actually, no, I won't tell you what I think. I'm not certain.
That's all right. I will have a read.
The proposition in law, as far as as I understand, is rather that if you use the wrong characteristic and you try to shoehorn a without prejudice conversation into an issue where there is not a dispute between the parties, it simply falls away. It just doesn't work. In the same way as if you use the idea about the protected conversation and statutory force is it has to be prior to termination.
Yeah.
So
yeah.
If you're starting that conversation and then a termination date arises, it's likely there's an issue in dispute at that point because, of course, you're contemplating, both sides have it in their mind. There's the contemplation about dismissal. But if you suddenly raise it post-termination, it's not going to work. And so that's the difficulty.
Yeah, I think I had a similar case, and I think on the heels of this example, I think it might be helpful for both yourself and Simeon to sort of, even for the benefit of our listeners, to kind of maybe delve a little deeper. We could delve a little deeper into what really constitutes a dispute, because there seems to be a misunderstanding that the minute there is a difference, you know, in the way we are seeing things, the employer and employee are seeing things, they just think it's a dispute, when actually, like in the example you just quoted, that was a grievance, and no matter what, that grievance should have still been heard and responded to, gone through the appeal stage, etc. But in the example that I've had, this was a very simple sort of redundancy process where this employee had well under 2 years service. There were no protected characteristics. There were some performance issues, but equally that was a genuine case of redundancy. And, you know, conversations had commenced. And like you say, they had already agreed what the last date was going to be, what the package was going to be. And one of the even though the employee was not entitled to any statutory redundancy pay, the employer was being quite generous and saying, this is how much we're going to pay, etc., etc. And there was just one question from the employee to say, well, I suppose you're, are you sort of getting rid of me because I am the youngest in the team? And from what I had been, provided with by the client, it was very clear that that was not the case. It was a genuine case of this one position had to go. And the employer, before the matter came to me, of course, had already had these conversations, had initiated redundancy consultations. But when that one question came up, they panicked and they thought she was pushing back on the redundancy, having agreed everything. And they suddenly moved to a without prejudice conversation. And things kind of got quite murky from there. It just got more complicated when actually they had already, by that point, they'd even put things in writing as to what was going to be the last day of work, what was going to be the settlement, what the only thing that was missing was a business case for redundancy. But yeah, and that definitely, in my experience, unnecessarily prolonged the dismissal and the eventual settlement. So that was one such case. But I think it might be useful for the benefit of our listeners to just delve a little deeper into when do we really consider a situation, just, something to be a situation of dispute, a genuine dispute, which is when we should be initiating, a without prejudice conversation, or like you say, if you're really seriously considering termination, then whether you should have a protected conversation. Simeon, did you want to shed some light on that and your experience, give some examples?
Yeah, I think often a good rule of thumb is, when considering whether there's a dispute, is are the parties actually thinking this is a situation that could potentially end up in an employment tribunal or in litigation? If it's something where that's not really in the minds of either party, then I think there's probably an argument to be said there that there's not an actual genuine dispute there that needs resolving, and therefore without prejudice conversation wouldn't apply. Trying to think of some recent examples off the top of my head. So I'm sure Chris may have some more. But,
I didn't mean to put you on the spot, but yeah, you're welcome to take your time, and I can go to Chris and come back to you. Chris, did you want to chip in at all?
Yeah, I think it might be useful just to go back a stage, because we're probably talking at a high level. In the sort of circumstances you were talking about, Sandhya, you've got an open discussion, and you've got a, if you like, without prejudice. Forget whether it's now common law without prejudice or the statutory enactment. You've essentially got an open conversation, a dialogue, and separately, running in parallel, you've got an off-the-record conversation, if we just put it neutrally. And often that is the case, because frequently, in order to get to a without prejudice position where there's an issue and dispute, you have to have a process running, typically an HR process. So you've got ill health, you've got performance, you've got disciplinary, you've got redundancy, and you've got to be, if you like, sufficiently advanced in that consultation process or in that disciplinary, that, as Simon says, that you've got that contemplation issue, that this could get very nasty, this could end up in legal proceedings. And as soon as you've got that generic formula, then you can hold the without prejudice conversation. And prior to termination, you can use both the without prejudice and the section 111A route, provided, of course, you're only specifically talking about unfair dismissal. Otherwise, you only want to be talking about without prejudice.
Exactly.
And if in doubt, I say I would always use both headings. I mean, even if I thought I was fairly confident only one applied, because why be too bespoke? You might be too limiting. You run the risk that you've run foul. But bearing in mind the idea of the whole genesis of the without prejudice conversation is to be able to enable the parties to have a, if you like, a robust and candid exchange. It's public policy, so that they can talk about their positions, put forward offers, discuss settlements with a view to reaching a compromise to avoid litigation and to resolve things, and typically to enter into a binding settlement agreement or a COP3 through ACAS. So from an employer's perspective, it's a very valuable management tool. I mean, certainly that's what I would always say to an employer.
Yeah,
Is
I would agree.
But you need to table it up properly. You need
Yeah.
to make sure that you know, get your ducks in a row. You need to know what you're trying to achieve, and then that will set out your strategy about how to approach things and what line to deploy, if you like.
But would you sort of say, so in even in the example that you gave, where the feeling I get is where there is a process being followed, be it a grievance, be it a redundancy, anything, do you get the feeling that the minute the employee starts to the employee may well, so let's, if we took the example of a grievance or a redundancy, grievance, there is no question of agreeing to something. You're obviously airing your grievances and the employer is required to respond to it. With regards to a redundancy, you're following a process where, you're talking about what the last date of work is going to be, what the settlement or what the notice is going to be, and what sort of redundancy payment is going to be, etc. And say where there's agreement, with all of that from the employee, but just that the employee is questioning something more for their understanding, do you find that there is suddenly this urge to then kick off a without prejudice conversation? Because I just find that sometimes if you initiate a without prejudice conversation, even where you have express agreement from the employee for everything that you're doing, they agree with the redundancy, they agree with everything. And yes, there's not necessarily a settlement agreement at the end of it that's being discussed, but there is redundancy pay, all of that. The employee is agreeing, just that they're asking some questions. And I find that when the employer then starts off with a without prejudice conversation, it gets their backup, the employee's backup, and suddenly the defense mechanism goes in and it becomes a situation of dispute when there wasn't one in the first place. And that's what I'm trying to sort of, avoid from happening for clients, or rather advising them to say, we've got to, weigh up what really is coming up as, what are the risks? If you really, just because an employee is asking you a question about the process or whatever, it doesn't mean that they're actually, excuse me, preparing to sue you. But you just got to weigh up what the risks really are. And then, yes, if you feel like a without prejudice conversation is valid or warranted, then we initiate that. Is that your feeling, Simeon and Chris?
I would go one stage further than that, because you have to approach it on the basis there are parallel processes in play. So there's an open conversation which needs to identify the broader context, so the ill health, the redundancy, performance, disciplinary, whatever it may be, and those concerns. And on the back of that, the piggyback is the principle that then the without prejudice conversation, those communications can be had. People understand the term off the record or confidentially.
Yes, yes.
But those have no legal connotations. They're meaningless. What we're talking about is a privilege from admissibility in legal process. And in order to attach that privilege, you have to make sure you fit either the without prejudice position. So there's got to be a dispute. There's got to be an issue that you're looking to resolve. Or you don't need an issue with the Section 111A route. You can simply, either side, doesn't have to be the employer, either side can have that conversation, and it is protected from admissibility in legal proceedings, but provided it only relates to unfair dismissal. So, for example, it wouldn't attach to automatic unfair dismissal through a protected disclosure, or any of the discriminatory aspects. So you've got to be very clued up as to what route you're following and why. And the danger is, you see, with the open conversation, as I say, you run the conversations in parallel, but they are different processes. If you can't complete a without prejudice conversation, there's no reason why it can't be amicable. There's no reason why somebody can't ask questions and there's a proper exchange of information.
Exactly.
It has to be an informed decision, and after all, it's subject to contract in the usual way.
Yes.
And a settlement agreement will require the individual to go away and take independent legal advice. So there's no reason why that can't be very conciliatory and very collaborative. But equally, you need to be robust enough that if it blows up, it's as though it never took place. Neither side can refer to it in employment tribunal proceedings. And really talking
Yes.
about, and then all you have is the open process, and then that will just run its course. And so, if within the open process the employer is talking about enhanced ex gratia payments and so forth, the danger is they've got all of that exposure. They've already the argument about whether the individual was, for example, dismissed is made out. The question might be then, was it for a discriminatory reason?
Yeah.
Their expectation is they're going to get that sum of money whether or not they sign a settlement. So by not separating out the processes, you run the risk that you are commercially and legally worse off.
Yeah. Yeah, I suppose one of the things that also comes up is where there is no protected characteristic, but somehow, where if somebody really wants to raise a claim, they still go ahead and raise a claim for a protected characteristic, and then they say it's unfair dismissal. We've also seen that in some cases. So yeah, I suppose that is something to guard against and bear that in mind when you run those two processes in parallel, isn't it? So you would have to be mindful of whether there is that protected characteristic, and if there is no protected characteristic, I see clients saying, well, there is nothing, Sandhya, there is very little risk here. And then the individual is, the employment contract is terminated, and lo and behold, the employer is still hit with a certain claim to say, well, I was recovering from a long-term illness. And that I believe is the main reason my employer terminated me. But actually that was never on the table, that was never discussed at all prior to termination. So there is that risk. Is that what you're saying? Is also a risk that sometimes is good to weather against, and thereby you run that parallel conversation. If you believe you want to sort of almost avoid facing that sort of a situation after termination.
Well, I think you have to be mindful about what you're trying to achieve, and the reason you separate out the process is partly so that you can have a candid and robust exchange, and you can have questions and facilitate settlement with information, so both sides can have that exchange. But if you're doing it on an open basis, it's admissible and either side can rely upon it, you have to be very mindful from an employer's point of view about what information you're sharing, because you may be absolutely making somebody's case out for them if they choose to bring a claim against you. And normally the only reason you're, for example, as an employer, willing to make a higher ex gratia payment than you're otherwise required in law to do. So, for example, the balance of somebody's salary, their holiday, their notice, any redundancy. But the icing on top, the extra compensation, if you like, is the consideration for entering into the settlement.
Yes.
If you're not going to get a settlement, why on earth, I would question, excuse me, are you making any?
Are you making ex gratia? Absolutely.
Because it can be used against you. It can also look as an admission of liability or fault. So for all the right reasons, you have a risk. Simeon, I don't know if you have the sort of different ideas on.
I think that very much makes sense, and yeah, I agree. Particularly on the last point, if there's not, if I'm entering a settlement, I can't see any reason at all why an employer would ever offer an ex gratia payment. It just doesn't make.
We see that a lot, Simeon. I see that quite a bit in my line of work, especially with not so much with clients who regularly work with us on the retainer, but where it just is a one-off project. And I've come across it quite often where clients unknowingly are willing to pay an ex gratia. And sometimes the reason for paying an ex gratia is not necessarily because they foresee some kind of a risk, but it's also because it's a long-standing employee. It's a goodwill gesture, and I said, okay, so if you're paying the ex gratia, have you considered signing a settlement agreement? Because how are you closing off all your sort of dose to risk in exchange for the ex gratia payment. And and interestingly, employers actually have, at that point, it comes up that they haven't even thought of a settlement agreement. That's another common thing I come across quite often.
Yeah. Funny enough, I've actually had the reverse of that, where I've had a couple of settlement agreements recently where there's been no ex gratia payment at all, and all the employee is getting is what they're legally entitled to already. And so I can't see there's any reason for them to sign the settlement agreement. And so then it's a
Yes.
case of going back and negotiating. So I do have sort of the reverse side of that coin more often than I
Yes.
expect, actually. But yeah, it does come up.
Yes, that's also. I mean, I must just pause there on the. So when we were having this discussion at the chamber meeting, your colleague also I'm not sure if that was your case or a colleague's case, but it was. He mentioned there was a Supreme Court ruling on a very high-profile discrimination case. I mean, if you are allowed to speak about it, he said there was a case law. Is that something that rings a bell for you, Simeon? He said that was possibly a case that you had dealt with or your
Wasn't
firm had
someone
dealt with.
you may be thinking of? We did. I wasn't directly involved. I watched. I was sat. It was back when I was a trainee, so quite a few years ago. But we had quite a big disability discrimination claim.
That was
Um,
it. Yes.
it wasn't in the Supreme Court, but it did go the full way. And I think in the end, the client ended up being awarded close to £1 million. So it was a pretty big, and
Mm.
it was a high profile company involved. Um, it was a few years ago. I was training, so I'd be scratching the barrel of memories there. But it was. I just remember for me, so as a trainee, the most interesting part was watching some of the cross examinations. It was a very interesting case, whereas an employee who she'd been fairly senior in the company, and she'd been on a very upwards trajectory, always outperforming targets, doing extremely well, getting promoted. And then, very sadly, she had a workplace accident which left her in a wheelchair for the rest of her life. And it was not long after that she was dismissed on redundancy grounds. And of course, the claim that we were bringing there was that she was being dismissed on the basis of her disability. And so we took that claim and went all the way. And although I wasn't directly involved in it, it was certainly sitting on as a trainee. It was a very interesting case, and as I say, she ended up being awarded close to £1 million. So it was a very interesting case there, with quite a lot of elements to consider in terms of the disability discrimination, and it was quite a lengthy hearing just to deal with the sums that we paid in the end. So it was very interesting, particularly as a trainee in the early days. Pick up some experience on that. So a very interesting case.
And speaking of that example, also as lawyers from your clients, do you also come across situations where you can see both sides? And when I say client, I mean, say your client is the employer, and you can see that this is a genuine case of long-term disability, and employers, given the situation, whatever the situation that they feel they are in, are asking you for solutions on trying to terminate the contract of that employee. And what is your advice for employers who are thinking along those lines? Obviously, yes, there is the Equality Act. Yes, there is occupational health. We have all of that and we've gone through it. But sometimes I think employers, excuse me, do struggle to see the wood for the trees, even though you lay out the risks and the costs of those risks to them. I think they'd still struggle to see it until, like in the example you've just quoted, they are well and truly in the midst of a high-profile disciplinary discrimination tribunal with a settlement of £1 million staring at them. As consultants and as advisors, obviously it's our job to try and avoid them from getting in that situation in the first place. But in your experience, what is, and given all the cases that I'm sure you've dealt with, what is your advice to employers? I'd be really interested to understand.
I think it's always just stand back, take a breath, look at it objectively, and think, what is the actual reason that we need to let this person go? What can we use to justify it? Because obviously the last thing any employer wants to do is get embroiled, as you say, in an unfair dismissal claim, and that goes all the way and ends up being litigated, and all the costs and time involved with that, and publicity and so on. So it's always just to look, what's the underlying reason? How can we justify this? Are we following the correct processes? And got to do it by the book. You've got to follow any internal processes you've got. It's got to be absolutely fair, transparent. And if there's any whiff of any other reason behind it that wouldn't be fair, then you're already on loose ground there. So I think it's always step back, think about it objectively, and of course always take legal advice and do discuss it without making any hasty decisions.
Yeah, I agree. And do you think that works every time, or
it's not going to work every time? Of course, you can't foolproof any kind of claim from being brought.
Yeah.
But I think the best you can do is make sure you are following the correct processes, and then if you are, you should be in fairly good stead, and hopefully any potentially vexatious claims that might be brought, then you've got the arguments to rebut that. But yeah, I think as long as you're following the correct processes, then you're doing your best, and you should be in good stead.
Yeah. Chris, anything else you'd like to add there to that?
Just to circle back and just to say the idea of the settlement, and although it can be propositioned by an employee under the Section 111A route, typically it's only brought as a without prejudice position on a constructive dismissal from an employee. So typically it is normally from the employer on both fronts. But the reason an employer should always look at these things is because it's about damage limitation. They're having in mind the potential risk of claims that can be brought. And in addition to the claims, there's the management distraction, all the costs, and of course there's the uncertainty of litigation. So you can compartmentalize the notice. You can look at what the maximum claim for unfair dismissal is, which typically is a year's salary up to the £118. Discriminations uncapped, so you might be looking at 2 or 3 years loss of earnings, and of course you've got the injury to feelings, the Vento guidance. So the statutory claims typically trump and totally outweigh the contractual, unless you're looking at sort of big city bonuses. But typically the statutory claims can be huge. And therefore the rationale is, in terms of the objective, is to draw a line and achieve a clean break. And that is what should be at the forefront of the employer's mind. And that is really why part of the opportunity in the without prejudice or the protected conversation is to explain to the employee why it's also something that's beneficial for them. It's advantageous for both sides, because the alternative, if there's no settlement, is just that you have not got your settlement.
Absolutely, yeah.
Why on earth, we were talking about why on earth would the employer be more generous? Because you're potentially funding a claim against you. Why would you want to do that? That should be your incentive and consideration for entering into the settlement. And you've got all the risk inherent and the uncertainty of whether or not a claim will be brought. So to my mind, it's part of having a very clear, defined aim and objective. And if you're big and bad, you decide you don't want a settlement agreement as an employer, fine, but it's prudent to consider one in virtually every single situation.
Absolutely. And like you say, especially where there is an ex gratia payment being made, yes, it's almost a must that you consider it and you try and achieve, try your best, because that's the commercial.
Because you sell on an open basis. If, for example, if you're going to be made redundant and we know your age profile, we know your years of service, we can calculate out your notice and your statutory redundancy payment. So if you're currently in a pool of candidates for selection for redundancy, if the consultation moves from an unassigned or at risk to a termination situation, at that point we can calculate what your payments will be. But on a without prejudice basis, or Section 111A, in addition, we're willing to be more generous, and we can give you this additional compensation too, and the tax treatment will be advantageous because it should be a lump sum tax-free. But in return, we want a settlement agreement, and with that settlement, you get return of property, confidentiality, and a smooth handover of any work that needs to be done, non-slagging off. You can have so many more contractual elements that you can import into the arrangement, which are all part of this control. But it's a risk factor. Some employers are more risk averse than others, and some are robust enough.
And I think Simeon made a very valid point, which again I've come across in my line of work, where there's nothing being offered as ex gratia. They just are offering either the statutory or the contractual, and then they expect a settlement agreement to be signed. And it's I've had the job of explaining to a client that if there is an expectation for a settlement agreement to be signed, then the right thing and the prudent and the commercial thing to do is to, in exchange for that, to offer an ex gratia. So that's another kind of conversation to be had, I find, as well. So it works both ways. And have there been, I don't come across this as much, but Simeon, I think you touched upon a case. Was it in the examples we just discussed? I'm talking more about health and safety now, where, because that parts of health and safety also fall under criminal law, isn't it? So where there's been an accident at work, and then you talk about, like you said, there was a long-term disability, and then there was this discussion. I mean, was there at all in that situation? Are you aware? Was there, any kind of efforts to, I suppose any case you are going to try and settle out of court. But how does a health and safety breach complicate that? Can we just shed some light on that?
To be perfectly honest, I don't recall, I'm not aware of on that particular case, how that came to, I'm sure it did come into play, and I know that there were lengthy settlement discussions that ultimately didn't end up going anywhere, and actually helped in the end with the award that was made in favour of the employee. To be completely honest, I'm actually not sure on that particular case how that came into play. I'm not sure if Chris has any thoughts on that particular one.
Well, typically, if proceedings go to the employment tribunal, the tribunal not overly concerned as to how the injury arose in a disability case. So it doesn't matter it's workplace injury. They would be looking at the effect of any reasonable adjustments that could be made. So i.e. they take the individual at that point. They don't necessarily look at the history of how you get there. But I would see them as separate and discrete processes, because you can't obviously stop somebody typically making a protected disclosure, whistleblowing, and it would be an automatic unfair dismissal if you dismiss somebody. It's victimization if you did that, and it's, again, you're back into your uncapped discrimination award of compensation, and you can't, as an NDA, as a matter of confidentiality, prohibit somebody from reporting to their regulator or, for example, the health and safety executive, if there was serious malfeasance or something, criminal responsibility as a result of breach of health and safety obligations. But that's not to say you can't contract out somebody's claim for compensation.
Right.
So the employer might, the sensible thing is you dust down your insurance policy, you put your insurers on notice about that, and obviously you square everything with them before, because you don't want to fall foul of your insurance provisions. But there's no reason why you can't waiver and compromise all the civil claims. And you might very well want to have a one-stop shop. So you might very well want to include personal injury as well, depending what it was. But of course, that's going to be typically dependent on medical evidence, and sometimes those claims have a much longer shelf life, because you need diagnosis, prognosis. You need to know the effect on somebody's ability to,
Carry out their
move
job.
forward and so forth. So, but you can certainly compartmentalize and sort out the claims, and you can compromise all of the claims, but you can't stop somebody making the necessary reports as they see fit to regulators,
Yes.
criminal authorities cooperating with the police and investigations, HMRC, all the usual carve-outs.
You just reminded me of one case, Chris, that came up. This was a case that I was sort of assisting. This was a care client, and there had been an assault by the service user on the employee at work. And yes, of course, that went so there was a grievance, and then there was an appeal. And obviously there was also then a claim. That case did get settled after a very long drawn negotiation back and forth. But I just have been reminded that actually, because there was the health and safety breach element to it, there was also from the employer's perspective, it also triggered their employer's liability insurance. So that aspect was also there, other than them having to just look at it as a settlement agreement in relation to the claims that were being brought in court. Now, in tribunal. Now, what I can't remember, and pardon me for this, because with the exceptions on non-disclosure, whether this was pre-lockdown, and I can't remember whether things like whistleblowing, because she was also whistleblowing on the policies, etc., that were being followed, or the lack of them that was there to safeguard against care workers being attacked like that by a service user within that firm, and risk assessments, etc. And I can't remember whether at that point, pre-lockdown, there were these restrictions around or exceptions where it said if you're whistleblowing on certain policies, those can't be included within a settlement agreement. But either way, that case was settled. And for the benefit of more the employers, I just wanted to highlight that when something like that happens, it also tends to trigger your employer's liability insurance, besides you looking at just the tribunal, or rather the settlement route pre-tribunal. Has that been your experience as well in any cases where there was health and safety issues?
Sorry, because
Yeah, sorry, no, Simon, you've been talking.
yeah, that's what I was going to say. And I haven't directly come across that, but I imagine that I can see that being the case, and I wouldn't be surprised to hear that. Certainly.
Yeah.
That's very
Yeah. Interesting. Yeah. And I think a lot of times, again, I see this where, yes, where you have under 5 staff, health and safety laws many health and safety regulations are not mandatory. But equally, I also see that where there are more than 5 staff, sometimes employers can lose sight of what would constitute as a health and safety breach and what would just constitute as either a contractual breach or any other breach. I find that reminders are necessary as advisors to employers, to say you might want to just check in with a health and safety specialist for something like that. Because somehow it just, even though there is that, the statutory requirements around, first aid kits, etc., all those health and safety, the checklists that you're required to follow and the risk assessments are done. When a situation arises, I find that the health and safety, element doesn't get picked up straight away. They look at it as an assault. They look at it as, oh, it's an assault, it's a criminal thing, or if a grievance is raised, but somehow the health and safety element gets forgotten until somebody reminds them about it. And then, of course, you open this other Pandora's box about what are the implications for an employer as a result of that breach. That's something that, again, comes up quite often for us. So, yeah. Have you had the same thing, Chris?
Yes, but I think more peripherally. If you're acting for an employer, your go-to immediately is if there's a workplace incident where there's a risk of health and safety, or certainly an injury, you immediately say, turn to your insurers, notify your insurers, because you mustn't ever do anything that potentially would invalidate your cover. So everything you do, you run through that. And most insurers are fairly sort of relaxed and laissez-faire in terms of employment strictures. They're not going to sort of want to be too interventionist, but they're just going to be very mindful that there shouldn't be any admissions, for example, as part and parcel of those discussions, and dealing with matters, or at least if they are, they're sufficiently damage controlled and contained. But there's obviously a difference between the sort of bringing a claim or looking to bring a claim and contracting out of it, and the ability, the individual's ability to notify these third parties, and particularly health and safety executive, or indeed the police, or other law enforcement agencies, and that's what you can't contract out of. That's a confidentiality issue, as opposed to not an NDA issue, as opposed to a claim as such. And the reason it's more peripheral generally in the employment context, I believe, is because it doesn't necessarily get the individual more money. Notifying the health and safety executive and putting the employer at risk of a fine may be a legitimate line to put an advance as to why you ought to get a better settlement. It may be something that the parties are astute to in terms of their exposure, and both sides are looking at sort of an overall settlement waiver. But once you're aware from an employer's perspective, you can't restrain, it would be unlawful to try to restrict the individual from making those disclosures, then actually often it becomes something, well, that's fine, you be you know, that's entirely your prerogative. And indeed, to overstep the mark, I mean, it's something that's important to note with both without prejudice and the section 111A. If you purport to do something which is overzealous, so we say it's totally unreasonable, is runs a risk that it's improper behaviour, and putting it's abusive, then you run the risk that your settlement is being undermined and may be voidable anyway.
Yeah.
So sometimes a more direct, that's fine, we understand what your case is, insofar as that element's concerned, that's for you. You do whatever you think you're minded to do. But insofar as the employment aspect is concerned in a claim arising, which can be put in the employment tribunals or the courts on a civil basis, then we can look at those, and we can look to achieve a compromise and a waiver of those claims. And that tends to be, I think, the way most employers will look at things. Because unless you've got a crusading employee, they may not, unless they feel a real sense of, you know, they've been put at risk and they should never have been, then typically it's less important, because it doesn't actually deliver to them a personal remedy, a financial one at least.
Yeah. And just to go back to the case law you were just talking about, Chris, I've just looked it up, and that happens to be, you know, on the without prejudice case law that you were saying. It was BNP Paribas versus Mesotero. That was the case.
It's
where the employee.
It's certainly, I remember
that was the one. I know you would.
Yeah.
Yeah. It was BNP Paribas versus where the employee argued that she had suffered direct sex discrimination and victimization because she had raised a complaint on her return from maternity leave. So that was the crux of the case. But I just came across, just again, if anybody wanted to just go and have a look at this, there was another case I came across, a useful case to look at for pre-termination discussions, which again, I know we were talking about a lot of during this roundtable, where you have a protected conversation, is a famous case law happens to be Phaeton Farrell Timms LLP versus Bailey. This was a 2016 case. And in this case, Ms. Bailey was a secretary at a firm of surveyors, and she joined in 2009, worked there until she resigned in 2015. And she argued that she resigned in response to her employer breaching her contract of employment, and therefore she brought a claim of constructive dismissal. So that's just the crux of the case. But in order to understand, for again the benefit of our listeners, what the context of a pre-termination discussion, a protected conversation needs to be, that's a good case law to refer to. That just came up. But yeah, I think I hope this discussion is going to be useful to members of the chamber, for especially those who employ staff. But yeah, do you have anything else to add, Simeon and Chris, to that?
Yeah, I think basically any employers/employees out there who have any queries, then yeah, always seek legal advice, speak to someone like Chris or myself, and we're happy to help.
Absolutely. Yeah. And yeah, that's all really good and very helpful. And yeah, this meeting will be held again 2 months hence. Beth will be sending out announcements, and that's not going to be during the holiday season, so we will hopefully have more people attending. But I just think it's still been a really positive discussion. So thank you so very much for your time and for contributing.
Thanks very much.
All right.
Pleasure.
I think we just thank
Cheers.
you, Chris and Simeon.
Bye-bye.
Take care.
Bye.
Thanks very much.
Bye.
Bye.
Thank you.